and carry away minerals other than the said minerals.
Yes.
So the lease is for a specific mineral. If
Yes.
the state is entitled to enter upon the land for exploiting any other mineral,
Yes.
provided if you cause damage to his right, you have to pay compensation.
Yes. Now, there is a form of the application in which the lessee lord had moved the application, which is also prescribed, that is Form I. Probably at page 114. Form I, second page, it's a Romans small 6. He has to specify the mineral or minerals which the applicant intends to mine. My Lord Justice Pardiwala has got this one.
Which page?
Well, the Form I, Form I,
I also see clause 2 at the part 6.
Clause 3, Roman 6.
Yes. What page was that?
My book is 114.
116. Roman 6.
Form I.
114, 116 maybe.
114. Minerals or minerals for which the applicant
Yes.
is intended. If you see
And the
clause
period.
part 6, provisions relating to rents and royalties, for clause 1 says that rent and royalties to be free from deduction, but clause 2 is very important. For the purpose of computing the said royalties, the lessee shall keep a correct account. Now what follows with both of the minerals produced and dispatched. The accounts as well as the weight of the minerals in stock or in the process of exports may be checked by an officer. So therefore, the liability to pay royalty
A rule.
So that time he has to pay.
is payable. The liability to pay royalty arises when the decoupling has taken place.
Yes.
Namely, that the mineral has been extracted and at the point of removal.
Yes. So that's the point of decoupling, not at the time of grant of lease. At the time the land is as such, we transfer the land also to occupy. Unless we transfer the land, the lessee cannot do the mining. The mining rights will be useless. So that mineral rights and the lease of land go together. And the lessee has to specify in the application what minerals he wants to mine, the period, the extent, the details of the area. So he's making a conscious choice. And even with respect to period, the law says minimum 20, maximum 30. So there is a range of 20 to 30 between which the applicant and the state government will have exercised their discretion, and a bargain will be there to fix the period, exact period. It could be 25 in between. So it's not that contract is absent, in the case of state granting.
Now what next? Sorry.
Mr. Dwivedi, what Mr. Pardiwala, Justice Pardiwala had just now mentioned about
Yes.
Giving up, page 137.
Yes, Manoj.
Now don't look at it so seriously, but when a miner goes down
Yes.
in order to extract the minerals for which he has already paid something, and he finds a placard there Queen Isabella is already here
Yes.
or was already here. And he says, I give up the rights for.
Yes. Yes, that's right. So that was the first point which I was making, that under the Act, rules, forms, the alienation or segregation, separation or decoupling of minerals from land happens upon exercise of the mineral rights post grant of lease.
Again, let's take it again.
The alienation, segregation or separation, which is the more appropriate term, or the decoupling of mineral from land happens under the 1957 Act, Rules and Lease, Form K. Only upon the exercise of mineral rights by the lessee and not at any prior point of time thus the law is consistent with the natural phenomena of the minerals taking birth and acquiring shape in the womb of the earth.
Subsequent to
And second, my lord,
lease.
the lease itself shows that one, this is a contract, albeit statutory. But the essential elements of contract, namely the making of application, with an undertaking to comply with law, including payment of royalty, and the acceptance of the application by a grant order under Section 4. Along with execution of lease, which states that it is an agreement, would show that the lessor and lessee have to agree to the terms.
Right.
So when
More than this, Manoj, if the central government itself does the mining under section 17(3), it will have to pay royalty, dead rent, surface rent, at the same rate at which is payable under section 9 of the Act, as if, the words are, if such, as if such mining has been undertaken by private person. This is a fiction created by central government, rather by the parliament itself. That even central government, if it does, is treated to be a private person. But we are told that it's a relic of past.
so when Form K is executed, is it a grant of a mineral right?
Along with the land, the mineral rights are also granted. But for the lease, section 4 says there will be no mining except under the lease. So the mineral rights are transferred, they belong to the state, they are transferred. I can do mining myself, the state can do it itself. Reserve it. Earlier, till introduction of 17A, that is 10th of February 1987,
A mineral right?
the state government needed no approval of the central government. 17A. But after this, under 17A, the state government, if it wants to reserve, under 17A2. So now we need approval of central government, but up to 87, no approval was required. We could say that we will do the mining under our own corporation ourselves. Now, section 17(3), when it says that central government will pay royalty as a private person, it is acknowledging that the land and the mineral belongs to the state. And that is why it agrees to pay royalty. It is not agreeing to pay tax to the state. It takes a lease in the same manner, therefore you pay the royalty in the same manner. There are only two ways in which the state government can be deprived. The first is either the Constitution itself provides that the land and mineral will vest in the Union. That is Article 279. Just say not 279. Shelf. That is regarding the economic shelf, the economic zone and
Yes.
Right.
297, I'm sorry.
297.
297.
The numbers were reversed, 297, 297. That's one way. The second way is acquire the land by means of an acquisition act by law referring with respect to entry 42 list 3. And in fact, if your lordship looks at Article 31AE, even private rights, existing leases, the rights can be extinguished by law, which then will be protected if it is under 31A, protected from challenge based on Article 14, etc. Notwithstanding anything contained in Article 13, no law providing for E. In fact, A and E can be read together. The acquisition by the state of any estate or of any rights therein, or the extinguishment or modification of any such rights. And then E, extinguishment or modification of any rights accruing by virtue of any agreement, lease, or license for the purpose of searching for or winning any mineral or mineral oil, or the premature termination or cancellation of any such agreement, lease, or license.
A farm, a huge farm of 100 acres.
Yeah.
100 acres. And I come to know that some part of my farm,
If you say
there
that.
are minerals. I cannot start extracting those minerals on my own because minerals not of my ownership.
Maybe it is a result.
Still, there has to be a lease deed,
Lease deed.
right? So lease deed will be only with respect to extraction or removal of the minerals.
Correct.
Land belongs to me.
And if your lordships are having all the yourself you want to do the mining yourself, then of course it will be relating to permission to excavate.
Royalty has to be paid because I'm removing it,
Yes.
Central government paid
removing the minerals.
tax. We were saying.
So that's the notion, my lord, that minerals always belong to the sovereign, the state.
Can you just read section 17.3 again, Mr.
We mean it
Section
17.3?
73, yes.
on the article of 285. There's a relative.
Where in exercise of the powers conferred by subsection 1A or section 2, the central government or the state government, as the case may be, undertakes prospecting or mining operations in any area in which the minerals vest in private person, it shall be liable to pay prospecting fee, royalty, surface rent, or dead rent, as the case may be, from time to time, at the same rate at which it would have been payable under this act, if such prospecting or mining operations had been undertaken by a private person.
17.
This is 17A3. Your Lordship wants me to read 17.3.
17.
70, where in exercise of powers conferred by subsection 2, the central government undertakes reconnaissance, prospecting, or mining operations. In any area, the central government shall be liable to pay reconnaissance, permit fee, or prospecting fee, royalty, surface rent, or dead rent, as the case may be, at the same rate at which it would have been payable under this act, if such reconnaissance, prospecting, or mining operations had been undertaken by a private person under a mineral concession.
Now, until the actual extraction takes place or removal, as this statute uses the word, is it possible, of course, that the right to the surface of the land vests in one person and the rights to the mineral vest in another person? That's also possible?
It depends on the terms of the lease, Milord, so what is being.
No, even before, forget the fact that there is a lease. Can there be a situation where the surface rights vest in A and the right to minerals vest in somebody else? For instance, service rights vest in the
It will go with
private
the land.
person
No,
and the right to minerals vest in the state.
it will go with the land. They are the right of the landowner. So unless by law or by contract, if notional separation is brought about in the two, Lord, it won't happen.
Yes.
But in private.
Before I leave this, Your Lordship, we just have one more clause of Form K, which is the last clause, 9 of Part 9.
You said 137.
Page 141, Lords.
137.
Begins at 137.
136.
You are saying part 9, right?
Part 9, clause 9, the last clause.
That's clause 9.
For the purpose of stamp duty, the anticipated royalty from the demised land is so and so per year.
Sorry for the interjection. My Lord Chief Justice's question. Kindly look at section 24A,
24.
24A, subsection 2. You might get an answer, my Lord. This is the question which fell from my Lord Justice Padiwala. Whether surface right of somebody, mineral right is somebody else. 24 capital A, 2, subsection 2.
Which section?
24A.
72.
Carrying it here.
24A has nothing to do with that.
In the rules, is
72 of the 1860 rules.
Section 24A doesn't answer that.
Question was because if the law contemplates a situation where the title to the surface vests in A and the right to minerals vests in B, then does the law then not provide for an artificial decoupling
Yes. No, law can,
even prior to removal?
it's not my submission that by a constitutional amendment or by a parliamentary law, or since the power of regulation is with them under entry 54, one has to see, my lord, to what extent they want to provide, my lord. So there will be some stray cases, if at all, my lord, where because of joint family or something, my lord, they divide amongst themselves that some part goes there, some part goes to somebody else, which is a very unlikely situation. And perhaps, my lord, may not be very helpful in answering the controversy which is your lordships are considering. And so far as 24A is concerned, it's only a case where, my lord, a private person's land, if somebody is.
Also recognizes that's a right. So yes.
of the 1960 rules.
Same as 24A, that
Yeah, but-
holder of lease will pay to the owner of surface.
Just a question. Let's fill for
It doesn't, these will apply only where a private person is having a land which is having mineral and then some third person wants to do the mining on that, then lease is granted by state government under section 4, but surface, right, surface Therefore, surface rent is to be paid to private person. That's all it's saying.
But just come forth, since we are not key area, do you want to add just one sentence without affecting Mr. Dwivedi's, because we are almost come.
It was considered by the Supreme Court in the Taxation I was mentioning at that time, considering the Hasbury's law of England, specifically saying that both can be held separately. But normally the presumption is that everything up to the center of the earth, including mines and minerals, rests in the person who is the owner of the surface. But there should be a legislation.
Take away the mineral.
Take away the.
That's what Mr. Dwivedi also.
This is the fundamental that the judgment is.
Just give us a citation. Please.
That is Tarakeshwar.
I will cite that judgment.
You're citing, then it's okay. Mr. Dwivedi is going to cite it. Mr. Dwivedi, don't forget, just when you are.
Yes, yes. So lordships have seen that stamp duty
Yes, we saw that.
is a different entry, but royalty is the measure.
Major. That is the major.
I will elaborate on this aspect when I again come back to the Constitution. Note that the submission would be that the mineral value is not the sole preserve of entry 50 list 2. Stamp duty, the law itself contemplates royalty as a measure. And if your lordship will look at entry 54 list 2 sales tax as it existed before GST,
Yes.
before the 101st constitutional amendment, 2016. It was tax on sale of goods. So mineral would have fallen there. And states have been recovering under Sales Tax Act, and it's the sale price. So the entire mineral value is a measure in sales tax also. Yeah, if it's a declared goods, minerals is declared goods, then central government will fix a certain rate.
Ceiling will be there.
That's the limitation. Constitution has given enough indication, the framers, as to what is limitation. And I had referred to 86.3 also in that connection.
That was section 15 of the Central Sales Tax Act.
Section 50, I'm grateful.
It says
Section 50.
4% or 3%.
4%. It's not followed by a prolix and expansive search all over the places, like searching a needle in the haystack, my lord, and then come out that this is tax. Occupied field. So occupied field has nothing to do with this. The parliament does not occupy the field of taxation. It's a limited concept. As my lord said, my lord, Justice Nagaratnam, my lord, that you can extract everything from 23. But there also to the extent. Yes.
Provide.
It's not sub silentio. Parliament by law provide extent.
That put cap on the limitation rate.
Not state government, not by rules, not by forms.
I'll just share with you.
So the 4% will come from section 15, but mineral value, the sale price of the mineral value will be its basis. And not only state tax, my lords. Parliamentary tax also, excise duty if they want to levy on the production of minerals, which they are levying, it will be based on the mineral value. If you want to impose export duty under customs duty, again, my lord, it will be based on mineral value. So there's no such thing, my lord, that other tax entries cannot, my lord, we at all have a measure which is connected with mineral value.
We hold it.
It's not the sole preserve of entry 50 list 2. Lord, that mineral value, the measure based on mineral value is not the sole preserve of entry 50 list 2.
Measure based on
Mineral value or a portion of mineral value. So how else a capacity of land can be measured? Salve said capacity of land should be. How do we determine the capacity of land? Same extent of land of same nature lying in Noida will have one value, coming back to Delhi, its location, its use, what the master plan is permitting. The moment you turn a lease, the residential land into a commercial land, the same land's value will go up. So the capacity of land depends on what it can produce, where is it located, what is the permissible use. Here the permissible use is mining for the mineral which is lying in the belly of the earth. So stamp duty, erstwhile as the sales tax stood, and even today oil, still there. Under 54, a sales tax is still being levied on oil, crude oil and also on variations, gas. And it is based on sale price of those items. And similarly in the Central Act, that is excise duty, customs duty, tax on capital assets, all of them will be based on this. So merely because you find that we have imposed a tax on land based on mineral value or half of mineral value. So this also must be decided, not assuming I'm wrong in this and Lordship doesn't agree that mineral value as a whole can be used. Why can't not a part of it be used? Let's say, as Odisha has done, percentage of half of the mineral value. So land's worth has to be determined in some way. Why can't we say 25% of the mineral value? And if it is still disrupting some national policy or something, there can be a dialogue. After all, states have voluntarily united to create a union. Article 1 says India, that is Bharat, is a union of states. So union and states have to gel together. They can't afford to all the time, despite the politics which is conflicting and introduces an element of conflict. But cooperation is also there, has to be there. So if there is some such situation arising or not, that government of India feels that their whole economy will go bust and there will be disaster, etc. I don't think any state possibly will be saying no to reduction of tax or to grant a holiday of tax. What are we witnessing around? Should we close our eyes not to what the states are doing towards the industrialists? Red carpet minutes. They can walk into the chambers of the government at any time. It's the common man who can't walk. Even the chaprasi that will stop him. Appointment hai ki nahi. But they can just a phone call and they will be escorted into the interior chambers. But I'm not casting it. That's the capitalist phenomena which is all over the globe, not here alone. So they can always walk there. In fact, these companies are themselves competent to pressurize the government to reduce the taxes. We can't do it.
Anyway, Parliament has the power.
Yes.
To impose limitation.
Yes, that's on one tax. One may say that all right, you can get out of this and then go into 49, go into stamp duty. This argument of 300%, 500%, At one point of time in 1990s, the figures have been given by the learned Solicitor General that 300, 500, because the royalties, etc., were very low and therefore that they needed revenue and that. But today, no state is revenue. The affidavit is silent on one very vital aspect. Post Keshavaram, at least in West Bengal, for the last 20 years, this tax is being levied. What disaster has happened? Should not the government of India tell your lordships, Lord, that this West Bengal tax has caused what impact? Has it burnt the economy? Has it prevented any obstacles for export, import?
In any case, state tax is high. Royalty can be anytime reduced by the government.
Yes.
Because
I'm grateful.
embargo is on increasing the royalty. That can be done only once in 3 years. But reducing it can be reduced anytime.
Government of India has more than one power, my lord, to tackle a situation of disaster. So let this not be a subterfuge, my lord, to bang the states. State of West Bengal is levying tax on mineral rights as upheld in Keshora for 20 years. What is the proportion of that tax to the total, my lords? How is it impacting? That's the real test. We say, well, the proof of pudding is in the eating. Here is a tax which is being levied for 20 years. Why don't you analyze that and tell the court, my lord, that what disaster is happening? Or are we to hallucinate, my lord, that some disaster is just the moment, my lord, the state touches 1 rupee per... Jharkhand says 1.5 rupee, my lord, per square meter for land. No mineral value. And it's lying stayed here, my lord, struck down by the High Court. Based on these series of cases based on para 34. What is nothing to do with mineral value? What disaster would have happened? The employees have not been paid their salary for 4 years. The tax is not a return. It's not a consideration. There is a compulsion. That's not a complete analysis. Compulsion, penalty, this. It's a recovery of amount to be spent by the state for its own needs and for welfare activities, not to give you back something. But the structure, the construct of Mr. Salve's submission was avoid the word tax, use exaction. So it's an exaction for return. Look at the essence of entry 50. It is also an exaction for return. So bring it on the same plane, and then it's a limitation. That's how we read down one tax on mineral rights as becoming something which is a return for mineral rights. Compensatory tax. Your lordships, after great effort, have been able to avoid compensatory tax in entry tax matter. At least 4 constitution benches and 1 7-judge bench, your lordships overruled. And everybody agreed that it can't be compensatory tax because compensatory tax means it's a fee. No, you are.
There are exceptions to that.
Yeah. So having knocked down compensatory tax in context of Part 13, now we introduce compensatory tax in entry 50 itself. So unless it becomes compensatory, it can't be equated, it cannot be a limitation. So these are the strange methods by which we alter the innate character of royalty. Now please see one more article in the Constitution, that's 294. And the purpose of showing this is that my right to land and mineral lying underneath in its belly is not a gift of Mines and Mineral Regulation and Development Act. The Parliamentary Act can regulate it, but unless it acquires all 294, all the provinces, state provinces will under all property and assets which immediately before such commencement were vested in His Majesty for the purpose of the government or of the Dominion of India, and all property and assets which immediately before such commencement were vested in His Majesty for the purpose of government of each governor's province shall vest respectively in the Union and corresponding state. Only the continental shelf was taken out. So the erstwhile ownership transferred to province. We continue to be the owner of the land and mineral, and whatever is subsequently acquired by the states under Land Reforms Act, under the abolition of kingships. So, किस पे है जहाँ लिखा है वो Lords, kindly have volume 1C. Volume 1C, which is a rejoinder submission.
Volume 1C. I think you have covered the core of your submission with
Yes.
this. Yeah.
At page 7.
Volume 4C. 4C. So 1C. 1C. 1C.
1C.
Yeah. Page 4.
Lords, have that? Lord the Chief Justice.
Yes.
Oh, at the bottom, I have done nothing but repeated what your lordships sutras, as Mr. Singhvi said. Kindly come to page 8. I have also mentioned entry 13 where some more than one sutras are involved.
Page 8, which?
Para 4.
Para 4.
If your lordship looks at entry 23 and 27 and 67 of list 1.
Entry 27 of list 1, right? Or list 2, sorry.
Twenty 23 of list 1. Highways declared by or under law. Please mark this. I'm drawing a distinction between entries which say by law, by parliament by law, or those which say by or under law. That will create a structural problem with respect to section 9 being understood as a tax.
Which entry were you saying? List 1?
23.
23.
Highways declared by or under law made by parliament. And then 27, ports declared by or under law made by parliament or existing law to be major ports, including their delimitation and constitution and powers of port authorities. And then 67, ancient and historical monuments and records and archaeological sites and remains declared by or under law made by parliament. Perhaps the lordship will notice a box there. Declared, earlier it was declared by law. But by Constitution's 7th Amendment Act 1956, it was altered. At the foot of that book, you all should see that earlier. Now, entry 12 of list 2 libraries, museums, and other similar institutions controlled or financed by the state, ancient and historical monuments and records other than those declared by or under law made by parliament. A reflection of that amendment is here also. And then entry 40, of list 3.
Same. Taxes and sorry.
Archaeological sites and remains other than those declared by or under law made by Parliament to be of national importance.
Under the statute itself.
Now compare this plot with entry 54, 52, 53 and 54 of list 1. Regulation and development of oil fields and mineral oil resources, petroleum and petroleum products, industries, the control of which the union is declared by Parliament by law. Parliament has to do this exercise by its law, and it cannot empower a delegate to make the requisite declaration or to lay down the extent.
That could be by a notification if it is
That's right,
under law.
because one legislature is dealing with another legislature, the central legislature vis-a-vis the state legislature. So, central legislature has to do it. It can't say that I'm delegating this power to the government or some other authority or officer of the government to lay down limitations. Now, 53 also in the area of oil fields and mineral oils declared by Parliament by law to be dangerously inflammable. So no government or officer can say, I will declare it, or I will declare in part and leave it rest to the government to declare. 54 also. Mines and minerals, to the extent to which such regulation development under control of union is declared by Parliament by law. Parliament also cannot say that, well, I have made the law, section 2 is there, now rest will be laid down by rules, as was earlier done in 1948 Act. It did nothing but said rules will be made. That was Constituent Assembly. But now that the Constitution is in force, it has to be done by Parliament, by law. So by law, you have to provide the extent. If you want to alter, reduce or increase a tax or a limitation or a different kind of limitation, has to be by law. But my learned friends have been taking your lordships to the rules, the forms, and all those stipulations, because it is general principle is that a delegated exercise is considered to be part.
63, then 62, 63, 64.
Yes, there are other entries also. 56 is also there.
Or under law.
Even entry 56.
Yes, entry 56. I'm grateful. 56 also. 60,
64.
64.
No, but this doesn't mean that everything has to be specified by the law.
Saying that.
The control, the extent of the control by the union has to be declared by the law.
Declared. Rest minor
Once the extent of the control is specified in of Parliament, then of course the rule-making power can supplement it.
Nitty-gritties and minor details may come by rules and forms.
Right.
I'm not saying that the form must come in the act itself.
Declaration cannot be by a delegate.
Declaration can't be an extent of declaration.
Right.
Parliament, your lordships have ruled in case that Parliament cannot say that section 2 I have brought in, now rest is to be done by government. So what minerals you are, the important aspects of the declaration, because you are extracting from 23. You are depriving the state legislature of its competence. That's the crucial thing. And that's why it says to the extent. And even where entry 52 did not use the word to the extent.
It is not there.
In Ishwari Khetan's judgment, your lordship's constitution bench has said that we will read in that word. Some meaning has to be given, my lord, to the word extent of,
Yes.
because you are extracting, depriving, denuding. It can't be sub silentio. Some nitty details can come in, the form can be prescribed. Many other things can be done. Right? How you will recover royalty, how you will recover surface rent, all that can be done by rules.
But under entry 52, the control of the entire industry,
Yes,
which is declared, is with the parliament.
Parliament.
Unlike 54. It is 54 is only to the extent to which it is declared.
My lords are right, but in Ishwari Khetan, your lordship said that even those words are missing in 52.
So they
But-
read it down.
But we will read it
That
because,
condition.
yes, I'll, if required, I can show that. In Ishwari Khetan words, I'll show it. Yes. For the moment, this distinction which I am pointing out has relevance to understanding the limit of limitation in entry 50. Entry 50 list 2 says any limitation imposed by parliament by law. Not by or under law.
And
So
that
the framers have been,
also, that extent to which is only in the context of regulation of mines and mineral development.
your lordship is right.
That's because
The words are missing.
further limitation.
The words are missing in 52. My lords are right. Absolutely right, Lord. But in Ishwari Khetan, if I may give this judgment is in volume.
So really speaking, entry 50 of list 2 makes it very clear that the limitation has to be by law of parliament.
Yes.
Second, that law is again, the content of that law is qualified by saying it has to be a law relating to regulation and development of
Yes. So the major aspects, the major policy aspects of the law must come by the law. They can't leave that to delegates. That is paragraph 11 of Ishwari Khetan, which is in volume 5A. And the citation is 1980, volume 4, SCC 136. 1980, volume 4, SCC 136. ठीक है, उतना ज्यादा paragraph is
So
devoted.
one thing is very equally clear that you have to also possibly concede. Ms. Bhati yesterday made just one sentence, but it was a very succinct sentence which she used. That the power of the state in regard to taxation is eclipsed not by a taxing legislation of the union, but by a regulatory legislation of the union.
That's right. No difficulty. With this statement, I have no quarrel. But I have a quarrel with the use of the word eclipse.
It is subject to, and therefore.
Normally, eclipse word, Lord, the doctrine of eclipse was deployed by lordships under when
Become a-
existing law under 372, Lord, is found to be violative of
applied
13.
that
13.
So then
Article 13.
it was valid when made.
Was it
now
stillborn or was it only under a cloud, and is the cloud lifted?
And once again, if you go to the nature, Lord, an eclipse happens when something covers the lunar eclipse or the solar eclipse, Lord, some other object comes in between. The law MMRD Act cannot come in between, cannot extract, cannot usurp, cannot arrogate. The relationship of 54 list 1 to 23 list 1 is of one character. And the relationship of entry 54 and entry 50 list 2 is of another character.
Can you just wait for a second? Hold your thought there just for a moment. I'll just.
Could you please repeat it?
Yes, the relationship between entry 54 list 1 and entry 23 list 1, entry 23 of list 2 is of one character. Namely, you can abstract, denude it as much as you want. As much as Parliament wants. And the relationship between entry 54 list 1 and entry 50 list 2 is of another kind and character, which does not permit abstraction, only limitation. My Lord Justice Nagratna has noted this Ishwari Khaitan's citation.
Yes, yes.
Para 11. Hypothetically, my lords, assume, my lord, that instead of the same expression was there in entry 23 as in entry 50, instead of subject to limitation, would it remain identical or would it bring about a substantial change in the nature of the relationship? In that case, then, even the regulation will always be exercised by the state. So therefore, when Additional Solicitor General states that entry 54 list 1 being a regulatory power can limit, I have no quarrel. Limitations can be imposed. But if it is said, when she says that this eclipses, then there is a problem. Stricto sensu, the doctrine of eclipse as propounded is for a different purpose, where either the competence is lacking or some other constitutional provision is being violated by an existing law, then, my lord, under. But let's forget that technicality and go by the literal expression. Even then, something should come in between. The only thing that can come in between is a limitation. So the power of limitation has its limits. So please discover the limit of limitation. It's not unlimited. Otherwise, the easiest thing was to accept Shri Brajeshwar Prasad's request to transfer entry 50 list to list 1. The easiest thing, brothers. If you can eclipse, then take it. I have already placed that. Every debate, my lord, which happens on the Constitution necessarily goes across the seas, my lord. The ships sail. So the House of Commons debate was read out to your lordships. It's no different. Mr. Percy, you can be substituted by Mr. Prasad.
I think that's what he wants to.
What he was wanting, Mr. Prasad was wanting. And on both occasions, that was not accepted. That's the key important thing. In a debate in an assembly where constitutions are being framed, so maybe speakers say so many things. Ultimately, what is being accepted and rejected is the important thing. So both in the House of Commons and here, although they were paramount, sovereign could do anything.
That Bridgeshwar Prasad part, can you just tell me which volume and volume?
Volume 4A at page 16, starts at page 10.
Mr. Dwivedi, your junior is a walking encyclopedia. We have noticed this in repeated constitution benches.
Yes.
So according to you.
The last time we allowed her to make that submission in the constitution bench. Today also, we are going to hear her after you have concluded for 5 minutes.
She is well armed today, Milord.
She's probably anticipated what's coming.
Volume 4A.
Volume 4A, 17 to 16, Your Lordship, and the relevant is at page 16. With regard to entry 15 and with regard to entry 54 is at page 10 and 12.
Just come again, please tell us.
Volume 4A. And the debate start at page 7, Your Lordships. So far as entry 54 is concerned, page 10 and 12. And entry 50 is page 16.
Yes.
Which you
End of the weekend, when we lay down our boots, we should at least feel that.
Another way of saying occupied field, nothing else. The principle of occupied field is completely unrelated to the relationship between 54 and 50. Can't occupy the field, occupy the...
Just to probe you a little bit on this, what kind of limitations would entry 50 contemplate? Would these be limitations contained in the law relating to mines and mineral development of an express nature on the taxing power? Or could it be something more than just that's one way of reading it, that you read the word limitations in a very narrow sense because you're carving out of the
competence
of the states. That's one approach. But does it have to be an express limitation on the taxing power itself under entry 50?
So in one, my lord, if I have to rely on a judgment, in 9 judges' judgment in Jindal, your lordship said it has to be express. All constitutional limitations must be expressly stated, either in the constitution or the laws. That's one. Second, my lords, the framers of the constitution have...
In what context? I think both I and Justice Ramana in our judgment, we referred to that, I think.
Yes.
So what context?
Judgment of the Chief Justice Thakur also, my lords. That was in the context of 304B,
304B,
which requires that if it is a reasonable restriction, then you have to refer to the president for assent. So the contention was that if every tax law is to be placed before the president, it being violative of 301, then all fiscal federalism is gone. So, my lord, the Chief Justice, my lord, you handled, my lord, the issue in a slightly different way. My lord, your lordship said that under 301, all taxes are not impediments. So, the people who are challenging, but they must produce enough material to show that it is an impediment on free flow of trade. Whereas the Chief Justice Thakur said that it can't be a restriction. That was the divergence. But at the end of the day, unanimously, the taxing power was disentangled from the grip of 3 and 4B so that the states are free now. That's in fact a very important aspect. That's para 28 of Chief Justice Thakur's judgment. That's 2017-12 SCC. Page 1. It's in volume 5 at page 2937. The discussion begins at page 28 under the caption constitutional limitations must be expressed. 3074.
Volume 5, right? May I place it? Just a second.
The power to levy taxes.
Just 21 seconds. Constitutional limitations must be expressed.
Which paragraph is that?
The power to levy taxes being a sovereign power controlled only by Constitution, any limitation on that power must be expressed. That proposition is well settled by the decisions of this court in Umeg Singh versus State of Bombay and from Bansidhar Prem Sukh Das versus State of Rajasthan. In Umeg Singh's case, this court stated the legal position in the following words: the legislative competence of the state legislatures can only be circumscribed by express prohibitions contained in the Constitution itself, and unless and until there is any provision in the Constitution expressly prohibiting legislation on the subject either absolutely or conditionally, there is no fetter or limitation on the plenary powers which the state legislature enjoys to legislate on the topics enumerated in the list 2 and list 3 of 7th schedule of the Constitution. The fetter or limitation upon the legislative power of the state which had plenary powers of legislation within ambit of legislative heads specified in list 2 and 3 of the 7th schedule to the Constitution could only be imposed by the Constitution itself and not by any obligation. Here one can substitute Parliament under entry 50. And not by any obligation which had been undertaken by either the Dominion or the province of Bombay or even the state of Bombay. Under Article 246, state legislature was invested with the power to legislate on topics enumerated in list 2 and 3 of the Constitution, and this power was by virtue of Article 245(1) subject to the provisions of Constitution. The Constitution itself laid down the fetters, limitations on this power, for example in 303, 286(2), but unless and until the court came to the conclusion that the Constitution itself had expressly prohibited legislation on the subject either absolutely or conditionally, the power of the state legislature to enact legislation within its legislative competence was plenary. Once the topic of legislation was comprised within any of the entries in the list 2 and 3 of 7th schedule to the Constitution, the fetter or limitation on legislative power had to be found within the Constitution itself, and if there was no such fetter or limitation to be found, the state legislature had full competence to enact the impugned act, no matter whether such enactment was contrary to the guarantee given or obligation undertaken by the Dominion. Again, in Bansidhar, this court reiterated the legal position. It is well established that Parliament or the state legislatures are competent to enact law altering the terms and conditions of previous contract or of a grant which under the liability of Government of India or of the state government arises. The legislative competence of Parliament or state legislature can only be circumscribed by express prohibition contained in the Constitution itself, and unless and until there is any provision in the Constitution expressly prohibiting legislation on the subject either absolutely or conditionally, there is no fetter or limitation on the plenary powers which the legislature is endowed for legislating on the topics enumerated in the relevant lists.
I think that's good enough.
Yes. So this goes on, I'm not reading.
No, then it goes on to part 30.
Yes. Justice Bhanumati's paragraph on judgment paragraph is para 281 and Justice Ramanna is para 185. But the only difference will be that under entry 50, Parliament can impose limitation, but must do so expressly. But what is there? I don't understand what is the hesitation. Parliament knows its policies, industrial policy, mines and mineral policy, everything. They know the export, import, the need of FDI and so on, so many things. What prevents them, my lord, from having one provision is saying that, and just look at 276, Article 276. I've already referred to Article 286.3. 276 is yet another provision where framers have indicated how they understand this limitation. Taxes on professions, trades, callings, and employments. Notwithstanding anything in Article 246, no law of legislature of state relating to taxes for the benefit of the state or of a municipality, district board, or local authority therein in respect of professions, trade, callings, or employment shall be invalid on the ground that it relates to tax on income. The total amount payable in respect of any one person to the state or one municipality, district board, local board, or authority in the state by way of taxes so and so shall not exceed 2,500 rupees per annum. So the framers, where they found that the measures are overlapping and they wanted to protect it, instead of eliminating it, they allowed it and said, here is the limit. So there is ample indication in 276 and 286.3, read with the Central Sales Tax Act. Why should not the parliament analyze everything? Look at the operation of West Bengal. By affidavits, we can't create, my lord, a doomsday. All state legislatures are responsible 300%, 500%. What prevents the parliament? Supposing if I say the parliament imposes 500%, 300%, then disaster. It can be said vice versa to that also, but we don't say that. We assume that they will act with constitutional responsibility. And
at one time in India, we had a 97% tax on income. Coupled to the wealth tax. In fact, the real rate of taxation went up to 103%. 103%.
So sometimes the taxes are also imposed to control the exports. We don't want a mineral to be exported. We'll say 100%, so nobody will export and sell here. So there are but Parliament knows all these things. The Finance Ministry knows, the Commerce Ministry knows. They can all deliberate and say that here is don't impose it more than this. Don't impose on royalty.
My father used to always.
Yeah. So पैरा निकाल दो उसका जिंदल का case, Your Lordship, my Lord the Chief Justice has Mohit Mineral. Your Lordships have talked about fiscal federalism.
Yes.
What is the citation of Mohit Mineral?
2022, 10 SCC, page 700.
At which para?
Para 50, 52. In fact, it begins at para 47. To 58, where your lordships held that state governments are not bound by the recommendation of the council. It's only recommendatory. And this principle was up to para 59.
Mr. Dwivedi, you have incorporated it in your
Submissions.
Yes, I have.
You may just read that paragraph. Just, we have 5 minutes to go before we close for lunch. Para 10,
Para 10, is it?
para 10.
Which volume?
1C.
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 Lordship, on the judgment or from the written note?
From your
Written
note,
note.
1C.
You have put it paragraph 56.
And 171.1.2.
Page 11 of your note.
Yes.
Para 10. Oh, yes. Para 10. Recently, this Honorable Court in Union of India versus Mohit Minerals, while holding that fiscal federalism is one of the important features of Indian federalism, held that the recommendations of GST Council cannot be held to be binding on the legislature. To regard them as binding edicts would disrupt fiscal federalism, where both union and state are given equal power to legislate on GST. One of the important features of Indian federalism is fiscal federalism. A reading of the Statement of Objects and Reasons of the 2014 Amendment Bill, the parliamentary reports and speeches indicate that Article 246A and 279A were introduced with the objective of enhancing cooperative federalism and harmony between the states and the center. However, the center has a 1/3 vote share in the GST Council. This, coupled with the absence of the repugnancy provision in Article 246A, indicates that recommendations of the GST Council cannot be binding. Such an interpretation would be contrary to the objective of introducing the GST regime and would also dislodge the fine balance on which Indian federalism rests. Therefore, the argument that if the recommendations of GST Council are not binding, then the entire structure of GST would crumble does not hold water. Such a reading of the provisions of the Constitution diminishes the role of GST Council as a constitutional body formed to arrive at decisions by collaboration and contestation of ideas. Neither does Article 279A begin with a non-obstante clause, nor does Article 246A state that it is subject to the provisions of Article 279A. Parliament and state legislature possesses simultaneous power to legislate on GST. Article 246A does not envisage a repugnancy provision to resolve the inconsistency between the central and the state laws on GST. The recommendations of the GST Council are the product of a collaborative dialogue involving the Union and the states. They are recommendatory in nature. To regard them as binding edicts would disrupt fiscal federalism, where both the Union and states are conferred equal power to legislate on GST. It is not imperative that one of the federal units must always possess a higher share in the power for federal units to make decisions. Indian federalism is a dialogue between cooperative and uncooperative federalism, where the federal units are at liberty to use different means of persuasion, ranging from collaboration to contestation. So, although the context is the GST in parallel power, but ultimately, the whole trend of this court's journey with regard to federalism begins with Keshwanand, where your lordship recognized it is a basic feature. Then Bommai and then ITC versus agriculture, 4 cases where lordships have felt that where there is lack of clarity, ambiguity, etc., then tilt in favor of protecting the state's niggardly powers rather than by interpretation, by some legal subterfuge, dilute it, reduce it, or obliterate it. That's the principle. And not only there, we are witnessing today, my lord, the conflicts between the state. Howsoever we may avoid this, the conflict where the governors holding the files, your lordship said you cannot. Orders were passed for premature release. Governor was not signing. Then in Periyapalan's case, your lordship said that no, you have no authority in that regard. So in so many spheres, Article 356 itself, your lordship strictly construed. The earlier laws were all overruled and a new law was laid down. So the whole journey of this court is to protect the state, and the surest way of killing the states, the federalism, is to squeeze and strangulate the fiscal power.
My lord, my learned friend is finishing now. It's there are a number of new points he has made because, frankly, we really opened the case. He has answered. How would your lordship like?
New really. Mr. Survey, where is the?
There are a number of points he has made on decoupling.
I'm not finishing. Just hold on.
Oh, you are continuing after lunch. I'm so sorry. I thought you were finishing at 1.
We want again alternate benches discharge. We'll discharge the alternate benches. Alternate benches discharge. Sorry.
I'm sorry, my mistake. I was told you're finishing at 1.
Lord, your lordships may give me 5 minutes on federalism, my lords.
I don't know. That's all right. These are
What is this?
well settled principles.
Yes.
So
My lord, there are some important points my learned friend has made, including on
Written
MMDR
submissions
today.
can be given first.
All right. You can give us a small note.
I don't think it's for you, Mr. Dwivedi. It's for the court to decide. May I suggest, my lord, after he finishes, give us half an hour.
Don't be so stern. I'm just lighter vein.
All right. We'll come back.
Give us 30 minutes, my lord, at the end.
and person will include juristic entity. The second situation is where the central government reserves land. That's 17.3, section 17.3. The third situation envisaged is where both either central or state government decides to undertake mining in a private person's land. That is 17A3.
Either central government or state government
undertakes mining or prospecting, etc., in a private person's land. And the fourth situation, however rare it may be, envisaged in Chapter 6 of the Mineral Concession Rules 1960. That is where the minerals are vesting partly in the government and partly in private persons. Now, these distinctions are significant for responding to Mr. Salve's argument that in the case of private persons, it's a contract. In the case of state government, it is purely statutory, no contract. I've already answered that there is a contract there. But see, Chapter 6 of the MC rules, where partly minerals vest partly in government and partly in private persons. Rule 53 at page 76. Provisions of Chapter 3 and 4 shall apply in relation to grant of prospecting license and mining leases in respect of minerals, which vest partly in government and partly in Chapter 3 and 4 all include minerals up to Rule 40G, that is Rule 31 and Form K. So completely at par. But once royalty, dead rent, etc. is obtained, then it's divided as per share.
Yes.
So there's no difference between a state granting lease and where this situation, the fourth situation, is existing. And even in the situation where private party completely, where the minerals vest only in the private person, that is Chapter 5. Rule 45.
That will be the fifth thing.
Chapter 5. Which according to me was the third situation. The Chapter 5 heading shows that minerals vest in a person other than the government. Now, Rule 45 provides for the condition of mining lease here also, except that there is a certain relaxation. Every mining lease shall be subject to the following conditions. The provisions of clause B to L and P to U of Subrule 1 of Rule 27 apply to such leases with modification that in clauses C and D for the word state government, the word lesser shall be substituted. Mining operation shall be undertaken in accordance with mining plans. So all those things are required here also. They can't, there also you can't avoid the mining plan. Now the only thing is that there can be some other ancillary conditions imposed by agreement in that. But the main thrust of the conditions in Rule 27 are applicable here also.
Yes.
And Subrule 4 says, if the lessee makes any default in payment of royalty as required by Section 9. So Section 9 is straight away applied here. And Rule 49 prohibits premium. So the range of restrictions, conditions, etc. are here also statutory, except for a slight relaxation. In essence, it's also a statutory contract.
Yes.
And all these four situations, the royalty source is Section 9. Source of dead rent is 9A. And importantly, Section 15 allows the state to fix the royalty for minor minerals.
Yes.
So one of the submissions from the respondent was that if it is a case of Section 15, then it will be a consideration, but if it is this, it will not be. So, well, one and the same concept derived from one and the same source, Section 9, or
Section 9 will not apply to minor minerals.
not to minor mineral. But my laws are right, it doesn't apply, but the nature of royalty is identical.
Only determination of royalty is left to the state
Yes, the
government.
authority is different. So the characters will not differ from situation to situation. It was also said that 9B and C, Mr. Singhvi said that all of them are tax. Some others said, well, Mr. Singhvi said 9C is not tax.
It's a fee, he said.
9B is tax. And 9B and C, well, there's hardly any difference. In fact, in both of them involve a quid pro quo, quite apart from the fact that a royalty does not come to the state government. In one case, it goes to DMF,
Respect.
other case to NMEET.
Trust.
And both have specific purpose. In one case, it is exploration. In the other case, it is rectification of the damage caused to the area affected by mining or the people. So yes, this is one extra source for enabling relief to the people who have suffered there. But ultimately, both of them are portion of a royalty and put in a separate fund for a specific purpose. So whether we need not enter into a controversy whether it is in the nature essentially a fee or, but even tax can be sometimes put in a separate fund for a specific purpose. So irrespective of this, it's a separate quantum, it's nothing to do with something coming to the state government. So this can't be a limitation to entry 50 list 2. You can't club 9, 9A, 9B, 9C and all of them, bundle them together and say that these constitute a limitation, impliedly.
Just kindly.
Now, one other submission of Mr. Salve was apply the principle Now, the other principle invoked was generalia specialibus non derogant. Entry 50 is special, entry 49 is general. Therefore, entry 50 will not be. So nobody says about that what is
The argument
contained.
was that since the constitution is bifurcated between taxes on land and taxes on mineral rights, taxes on mineral rights cannot be subsumed in taxes on land and buildings.
But we have not argued that it is subsumed there. There are two different aspects. One is what we contend is, as I said earlier also, that the measure based on mineral value is not the sole preserve of 50.
Right.
As long as the minerals have a direct proximate nexus with any other. For example, sale tax is based on it, but it is a sale tax. It has to be per necessity based on a sale price. Excise duty, it has to be based on the point of sale. And even Bombay Tires, which they relied, actually helps us when it says that excise duty can even include the cost of packaging. They say it doesn't matter as long as the excise duty is a tax on manufacture, you can have a suitable modification and you can contour your measures accordingly and add something here and there. So that's not our contention that tax on land is a tax on mineral rights. What they want to assert actually is that we are actually using a constitutional subterfuge or trying to a colorable exercise of power.
That in the guise of taxing land and buildings, you're
Yes,
taxing
we are doing that.
mineral rights.
That's right.
So as to be liberated from the limitations which are imposed on you. That's
So this kind of a contention has been repeatedly raised and rejected by this court that if in case in the context of income, RR engineering was a case where the haysiyat tax, the circumstances tax, based on income. The Lordship said that one is in 62 others, list 2 and other will be in the tax on capital asset is an aggregate. So as long as individually the tax is right, for the incidence should be falling on the field which is contemplated. If the tax is on land and the measure is not remote, not far removed, it is valid. So in order to sustain the respondent's submission, the lordships will have to hold not then that the measure based on mineral value is the sole preserve. Then obviously other entries cannot. Then obviously even sales tax cannot use it. Stamp duty cannot be levied on that. But every day the registrations of transfer of property is being done based on the value of the property. And this is an important aspect, because what happens is that sometimes this court will be limiting itself to saying that this particular measure is not available, struck down. And we stop there. Some other measure is adopted, then again there is a challenge. So the state must know clearly what are the measures which are available for imposing a tax on land. How should it be imposed? Cess and royalty struck down. So if we say, all right, this is a tax relatable to half of the mineral value, so where should we stop? Should we say a quarter? After all, mineral value emerging from the land has some direct relation with it, and some basis, it can be made a basis, part of it can be made a basis. Now, since Odisha is not going for the whole of the mineral value, is saying that not more than 20% of half of the mineral value. Can we do that? Now they say leave it to the smaller benches to decide. So once again, matter rebounds back. We can't take the full mineral value. We can't take the half mineral value. We can't take the quarter mineral value. So where do we stop? How do we determine the capacity of the land? But one thing is very clear. The tax on mineral rights does not include mineral-bearing land. In fact, some of the colonial councils on the other side said, even minerals are out. It is only mineral right. So even here, you can't take the mineral value, you just take the document of lease, like stamp duty. But they forget that stamp duty here also takes the mineral value, the value of the land. So therefore, Lord, the state must be clearly told, Lord, because otherwise will be every time doing something, every time, Lord, there will be a challenge that, look, there is some connection with mineral land and mineral value. And for the last 20 years, the states are not able to, other states apart from Bengal, not able to collect. This is lack of uniformity, Lord, in fact. If one state is collecting, and for 20 years, neither the central government nor parliament has written, Lord, to the state of West Bengal that you limit this tax to this. That was the best test. They could have told Bengal that this is high, leading to disaster. Please limit it. Make it half, make it 25%. These are all limitations which are permissible under entry 50. They can say, Lord, limitation means that ensure that the tax or some factor, that ETR rate or something which they have suggested, it should not go beyond this.
Just on a point of information, since you mentioned about West Bengal. West Bengal is deprived of the enhanced rate of royalty that was allowed in 1991.
Oh, we don't want enhanced royalty. We want our reserve. It's a question of competence, not the amount you are depriving or not depriving, assigning or not assigning. It's a question of federalism. The state must exist and state must enjoy the plenary power. If you want to limit, limit it. If you can deny something, deny it. Even limitation is denying. But this is significant that non-issuance of any directive, not including any provision with respect to state of West Bengal, shows that the government is satisfied that the tax which is being levied and collected for the last 20 years is appropriate and causing no disaster. 20 years is not a small period, 2 decades. So therefore, this principle of general and special, when does it apply? When the special provision must traverse the same genus, the same field. There is a general provision which covers a particular field. Then comes a narrower provision which covers part of it. Then you exclude it from the general. But if the two fields, if the two taxing events, the two taxing objects are different. Now here is the contradiction in their article. Mr. Salve says there's a neat division, no overlapping. And this is what Sundara Ramaiah also says. Whether we call it aspect theory, whether we call it neat division, or whether we use taxable event and taxable objects to delineate the distinction. Once the division is neat, then where is the question and where is the scope for applying this principle of generally a special but not derogant? There are two independent taxing fields with a different taxing objects or taxable events. And as the other side concedes, there is no overlapping, neat division, different aspects. So there is no scope for application. This will apply in cases, for example, I may just give an illustration where your lordships, several cases have applied, they have cited some cases, but they are traversing the same field, which is not possible in tax entries. Kindly look at entry 24, list 2. Industries subject to the provisions of entry 7 and 52, list 1. And just below is gas and gas works.
So in the case of 7 and 52, the moment a declaration is made by
Parliament by law,
the entire subject
the
is
industry-
taken away. Those industries go out of the fold of
24.
entry 24 because it's subject to the provisions of.
That's right. Now, the issue arose in this court whether 25 will go. Calcutta Gas Company case, 1962. This page पर है. Volume 5, page 209. It was held that union by law under entry 52 cannot extract the scope of entry 25. This is a case of special being carved out from industries because one particular industry is separately mentioned. So the field is same. 25 is 24 is industry, 25 is. And the relationship of entry 24, 26, 27, my lord, the Chief Justice has dealt with, my lord, in that case of RERA of West Bengal and followed Tikaramji and all those cases. So the structure of the relationship, see how the relationship of 24 with 52 drastically differs from 23 with 54. Because once the union declares under entry 52, industry goes to the list 1.
Yes.
But 26, 27 send the trade and commerce, production, supply, distribution of goods to list 33. List 3. In mines and mineral, both shift. The mines, mineral, both shift to list 1. But in case of industries, industry goes there, product, supply, distribution, trade, commerce, all shift to 33. My lords have noticed all this in RERA case. So these structural differences demonstrate a different kind of interrelationship.
RERA was a very interesting case because there the West Bengal legislature enacted an act identical to RERA. Identical to RERA in all, there was no conflict as such that one says X and the other says counter X. So Mr. Dwivedi appearing for the West Bengal government says, where is the conflict? Because we have done exactly what the center has done. So where is the bar on us? I think we remember very interesting. No other case has raised that issue really.
This is the only case.
This is the only case which dealt with that.
And since all these entries had been dealt by me was in ITC and all those constitution benches, so I said I will not defend that. But this was the solitary argument left. But very correctly held by Lordship's brother.
Competence.
लोगों ने कौन सा साइड किया था जन्म? That this theory will not apply in case of taxations because there is no overlap. They are distinct, either divided by taxable event, by taxable objects. Division is neat. I accept what Mr. Salve says, it's neat. But if it is neat, then where is the question of extracting from here or there? We have just to see that particular entry and see, is the tax actually in that field and is the measure having a nexus?
Now, what do you mean by, you can address it in your own turn. What do you mean by tax on mineral rights? I mean, how do we sort of conceptualize what is meant by tax on mineral rights?
So, it's a tax on the aggregate of mineral rights. Just like your lordships held in case of tax on capital assets.
That's on the aggregate of the
aggregate of all the assets.
SC noun and then Dillon, of course.
Yes. That is entry
86.
86.
86, I think.
Taxes on the capital value of the assets. Exclusive, one asset is excluded, agricultural land. So when it says tax on mineral rights, it's a bundle of right which always goes with the lease. The land is given for working this mining operations. And the rights are, you can enter, you'll also notice that rule and the clause in the lease itself which says you can enter, you can drill, you can excavate, you can beneficiate. So all those things which you are doing in the leased areas, including the right to extract and sell, that's the sum total of the rights. Because simply extracting and not selling is hardly any right then.
But when you tax royalty as a state, are you taxing mineral rights then?
So royalty, nobody is taxing now.
Right.
All the laws of all the states, including the West Bengal, which has been upheld in Kesharam, expressly excludes all taxes and royalty. That is because of India Cement. Kesharam has not attempted to indirectly overrule. It only said that related to cess on royalty, a particular. Taking a cue from that we can't tax on royalty, all the states changed. They took the mineral value minus excise duty, minus sale tax, minus this, minus royalty. So no state is taxing or having any component even
of royalty.
So there's no royalty in it. Although I personally feel, my lord, that cess on royalty striking down was wrong. Because royalty is a return. It's a kind of income for the state itself. And the state was using it as a measure.
But anyway, that is now, no state is doing tax.
No state is doing it, and that's not an issue. And it's not our contention, it's not then arising. The only issue referred to your lordship is Kesharam departing from that.
Right.
By correcting that error in para 34.
Which is the tax?
That's the limited error. So it's a bundle of rights, the aggregate of rights which is granted by the rule. That is what is the subject matter of tax, which is also connected with the mineral value, because ultimately as the exercise of mineral right, one of that right is to extract and carry away.
One thing, correct that the taxes on royalty are not being levied. The union comes out in Chhattisgarh, is 5% of the amount of royalty payable in. That is the state tax. Number of states are taxed. The levy itself is 5% of the amount of royalty.
That's a measure, 5%. That's why I'm submitting that actually that was, I would say that if a measure includes royalty, is rather better than having the whole mineral value a royalty. Royalty will be some percentage fixed by central government. So it's my income with respect to the transfer of mineral rights. That's what we have submitted. Now, if that is taken as a value, the tax will always be lesser than if you takes the whole mineral value.
To be precise.
By striking down cess on royalty, the result has been that the states are searching and groping how to take the measure. Instead of the whole mineral value, you take the royalty, which is a portion fixed by the union.
In correlation with the rate freeze.
ठीक है. So in Chhattisgarh, they should be happy that it is pegged on the royalty, not the whole mineral value. If you take the whole mineral value, it will certainly go up, not down. And that's why Odisha has taken half. And Jharkhand has completely eliminated just per square meter. So that to avoid all this controversy, this is mineral value or not mineral values.
Another aspect is
Yeah, Mali.
the definition of land revenue under 115 and 116 of the Tamil Nadu Act.
Yes,
Land revenue, it means so many types of, it says like, for example, water supplied, irrigation on the land,
yes,
lease amount, other sum payable, royalty.
royalty.
So royalty was included in land revenue. And
That's-
therefore the explanation included it. Therefore, under the Tamil Nadu Act, it was struck down.
Absolutely, that's, your lordship is right, absolutely
If
right.
the
That's
word
the
royalty was not there in the explanation,
yes,
the controversy with regard to MMDR Act
may
wouldn't
not
have
have
arisen
happened.
at all.
that's
The
right.
explanation got it in.
Explanation included royalty. Therefore, they expanded the arguments to say
Absolutely.
that it is encroaching in under the Central Act.
I agree, but absolutely, that's right. But what I am placing for consideration is that had it been royalty, because royalty is a portion of the mineral value. Central government fixes under Section 9. And it can fix, we are not questioning. Now that will be, let's say, 10% of the mineral value. So as it is, we come down from 1,000 to 100. And 100, then you impose some percentage of royalty. It's much less than paying 10% of the whole value.
There has to be some method. Yeah, some method.
So, I would think, my lord, that taking royalty as a measure should be permissible, my lord, and that enables the union to then.
Now, what else, Mr. Vedi?
Now, just one more aspect is, my lord, that one argument was raised that we are not the owners of land, we are the occupiers, so you can't. One minute. Question raised by Mr. Salve is Nauseter Associates.
Point for her to argue.
She has.
Sorry, Mr. Dwivedi.
Yes.
1 point.
I have a very brief note.
Hello.
This Nauseter Associates, how does it apply to what is the argument is take entry 45, 49, 50 neighboring. As I have understood, Lord, the words should be associated in the same entry. One is general one and the rest
You
are
can't read taxing entries that as if they form part of one
universe.
fasciculus, as they used to say in the 70s.
So this nocita associates.
Nocita associae means that when words of a general nature are followed by words of a more specific nature, the general nature of the words must take color from the specific.
It should be in the same provision.
Yeah.
For example, in this luxury tax.
Or as they say, birds of a feather flock together.
Yes.
That was another way of saying
Or the man is known by the company he keeps.
Yeah.
May not be true, but
Actually, in that sense,
because
they're all really shades of the same principle.
the idea is that
Nocita
take the
is
color. Don't let it flow much so wide that the scheme breaks down.
These are even independent taxing entries. You
Yes.
can't restrict one by
One by the other, so each has a different taxable event. You say, no, take it from that. Since land revenue is collected from the owner, therefore, here also it can be levied only on the owner. But for the respondent's benefit, if your lordship has section 4, sorry, section 3I, yeah, at page 38 and 39 of the written submission, 1C, I have given the cases on nocita associate. CI, 3I, expression mine and owner have the meanings assigned to them in the Occupational Safety, Health and Working Conditions Code 2020. This was amended by Act 16 of 21. Earlier it said, as in Mines Act 1952, and the owner, which paragraph? Page 38 of the written submission. At page 29, I have quoted. Sorry, page 29. This is the definition of mine. And at page 30, you'll also find L. Owner. When used in relation to mine means any person who is the immediate proprietor or lessee or occupier of the mine, or of any part thereof, and in the case of the mine business, the business whereof is being carried on by a liquidator or receiver, such liquidator, but does not include a person who merely receives the royalty, rent or fine from mine, or is merely the proprietor of the mine subject to any lease, grant, etc. So the lessee and the occupier are owner under the MMRD Act. So in any ways, even if one nocita associae is applied and we treat it as falling on the owners, so the occupier and the lessee are owner. For 50 years lease, which is now mandatory under 8A, you are the lessee and occupying and carrying on operations. And it's also a matter which also judicial notice can be taken that everywhere the lessees are paying property tax and all those things. In our house at Allahabad, it's on lease from the union and property tax is to be paid by the lessee. In fact, in that US case, which a young lawyer, Mr. Ghosh, had cited, the Supreme Court said that there are two different rights. The power to tax is to tax as a sovereign, and power to enter into a contract and grant lease, etc., is a contractual right. So the fact that you have given a lease and that you have not reserved any right to tax is of no avail, because tax is by virtue of being a sovereign for sovereign needs. You know, there's an interesting passage in Jindal with regard to abuse of power. First of all, your lordships have consistently said that abuse of power is not a ground to test the validity. That will be tested separately. Para 112. The court very interestingly has said that when you tax your own constituent. Because we states are wanting the investors to come in. They want the money to flow in. They want business. They want to give employments. So the constituents themselves create pressure. I would submit, Lords, that please take Para 112 of Jindal combined with RR Engineering, Lord Chief Justice Y.V. Chandrachud's observation that if you impose the tax so high, then the measure will lose and it will react on the levy and show that it's something else which you are doing. The character is lost then. If the two things are combined, then that resolves the issue of largely. And rest, Lord, Government of India has many powers to do. If some state is hell-bent, Lord, to destroy the union, its fiscal policies deliberately, then 356 is there not to destroy it. So why? In 355, they are bound to protect the federation. They can issue that.
Are you giving ideas?
The other hand, the states are suffering.
They can acquire. Supposing for a critical atomic mineral, some state is acting in a particular manner, they can acquire that land. That's at page 44.
Anything else now, Mr.
Yes, well, just one thing. It was said that in the same vein and context, it was said that resources are unevenly distributed. Again and again, it was harped upon others. And therefore, few states, handful of states having resources will blackmail or do whatever, sinister.
But the reality is, the states which have these mineral resources are the poorer states in this
I'm
country.
so grateful, brother. That's exactly what I wanted to submit, brother. That's Chirag Tale Andhera, jisko bolte hain.
The people are going from outside and exploiting the minerals.
That's right. Vedanta is, who's complaining? Vedanta, Tatas, Adanis, Ambanis. They are complaining, that this is too high. Your lordships have detagged that Assam case. We had given the state there was quite active and helpful, and so they given statistics that a company which is a government company is earning 10,000 crores per annum is not willing to part with 0.58% of that. In the last 20 years, the amount of tax which they have to pay is 1,500 crores, and their profit is 10,000 crores per annum. Because of the delay, interest has risen to by 3,000 crores. But leaving that interest aside for the moment, to judge the levy, 1,500 crores in 20 years and 10,000 crores per annum in 20 years. So none of these are coming out with balance sheets to tell your lordship how much profit they are earning from this. But they are trying to paint disaster, the doomsday, as if all states are hell-bent. They are something like Indian states earlier, who were collaborating with the British and trying to bring down the center. They constitute India. They are Bharat. Why will the states, Lord, we have surrendered all the powers? They were all representatives of states elected by states in the Constituent Assembly. And they surrendered the powers willingly, Lord, because they felt that the country must unite. So the larger share was given to Union. And now we are told that you are acting something like that, Lord, to destabilize and do whatnot. So this uneven distribution actually, my lords, is a boon, not a bane. There would not have been trade and commerce in the world and in India, Lord, if this differential distribution is not there. Some state has got something to give, another state has got something else to give, and that's how we unite. The economic unity is built on this differential distribution, which is being decried. And uniformity of price is yet another theme, my lords, uniformity of price. Does price depend only upon royalty or my lords, upon this? It will depend upon so many factors, supply and demand. The price will go up and down. These all leaseholders, my lord, and sometime back in the previous decade, they were all mining iron ore and sending to China, my lords. Their religion is one. As somebody said, my lord, that in times when Rome collapsed, it was said, my lord, that the Venetians continued to trade with the Arabs also. They used to go to Jeddah and everywhere, and they said the Venetians had only one religion, and that religion was Prophet. So one side had Prophet Muhammad, the other side had Prophet. Both had Prophet. So they are worried whether their profits will go down. And not concerned with this, as my lord said, that why is it? The real question is, why is it, my lord, that the regions which have got so rich in minerals, why are the people there poor? Even after 75 years is the question to be asked. Of course, even the states, we have to answer for that. And your lordships have been pushing this DMF and all those things and some penalties which your lordships imposed. Then your lordships have asked a separate fund to be created. Justice A.K. Patnaik has been appointed not to see, and then we have to bring a scheme. We will spend it on these things, hospitals, education institutions and houses and water supply. So he's monitoring. So much is being done by the courts to push the states. And so I thought, Lord, if today somebody would have, the two governments would have seen that these people, as Justice Krishna has said, the little man with little means, where is he? He's still there where he was. So this uneven distribution is, in my respectful submission, Lord, a boon. It helps trade and commerce. It helps mobility, people of one place going to the other place. And these companies, unless they produce their balance sheets, etc., they should not be heard to say that some disaster is at the offing, at the doorstep.
What else, Mr.?
Just one case I want to cite, Lord, which is the last in this field as occupied field, that is Monet Ispat, where Tulak and all those cases, Ingrid Rampur, were discussed. Tulak, your lordships had seen, my lord, this, even with regard to entry 23 and 54 relationship, since it is to the extent provided it extracts, how do the court approach the issue? When a state act is challenged, then the court will see what is the state act doing. Is that field covered by the MMRD Act? if the field is not covered, then my lord, this occupied field theory doesn't hit the state act. That is what Tulloch said. But Tulloch was dealing with the same license fee which Hinger Rampur dealt with. And therefore, my lord, they said that since the field is occupied, therefore you can't levy that fee also, because all fee entries are relatable to the subject matter. If the subject matter is gone, no fee. Kindly see page 2839 of volume 5.
Five pieces.
Kindly have paragraph 130. Para 130. Kindly have from para 129. The lordships also notice the debate of House of Commons.
Give us the PDF page once again.
2839.
I don't think so.
It begins at 2760. I am reading para 129 at page 2839.
2839. Beginning is 27.
Volume 5. Volume 5.
2760 it begins.
Even the middle page.
May I place, sir?
Yes.
Yes.
List 1, entry 36, Federal Legislative List, and List 2, entry 23, Provincial List in Schedule 7 of the Government of India Act correspond to entry 1, List 1, entry 54, and List 2, entry 23 of State List in our Constitution. It is interesting to note that in the course of debate in respect of the above entries in the Government of India Bill, the Solicitor General in the House of Commons stated that the rationale of including only the regulation of mines and development of minerals, and that too only to the extent it was considered expedient in public interest by federal law, was to ensure that the provinces were not completely cut out from the law relating to mines and minerals. And if there was inaction at the center, then the provinces could make their own laws. So by not imposing limitation, it is inaction. Thus, powers in relation to mines and minerals were accorded to both the center and the states. The same philosophy is reflected in our constitution. The management of the mineral resources has been left with both the central government and the state governments in terms of List 1, entry 54 and List 2, entry 23. In the scheme of our constitution, the state legislatures enjoy the power to enact legislation on the topics of mines and minerals development. The only fetter imposed on the state legislature under entry 23 is by the latter part of the said entry, which says, subject to the provisions of List 1 with respect to regulation and development under the control of the Union. In other words, the state legislature loses its jurisdiction to the extent to which the Union government had taken over control. The regulation of mines and development of minerals has manifested by legislation incorporating the declaration and no more. If Parliament by its law has declared that regulation of mines and development of minerals should be in public interest under the control of Union, which it did by making declaration in Section 2, to the extent of such legislation incorporating the declaration, the power of legislature is excluded. The requisite declaration has the effect of taking out regulation of mines and minerals from List 2, entry 23 to that extent. It needs no elaboration that to the extent to which the central government had taken under its control the regulation of mines and minerals development under 1957 Act, the states had lost their legislative competence. By the presence of the expression to the extent hereinafter provided in Section 2, the Union has assumed control to the extent provided in the 57 Act. The 1957 Act prescribes the extent of control and specifies it. So this can't be by inferences and other, you have to specify the extent. We must bear in mind that as the declaration made in Section 2 trenches upon the state legislative power, it has to be construed strictly. Any legislation by the state after such declaration trespassing the field occupied in the declaration cannot constitutionally stand. To find out what is left with the competence of the state legislature on the declaration having been made in Section 2, one does not have to look outside the provisions of the 1957 Act, but as observed in Bajnath Kedia, have to work it out from the terms of that Act. In order that the declaration made by Parliament should be effective, the making of rules or enforcement of rules so made is not decisive. So the rules, etc., are irrelevant. The declaration made by Parliament in Section 2 of the 1957 Act states that it is expedient in the public interest that the Union should take under its control the regulation of mines and the development of minerals to the extent provided in the Act itself. Legal regime relating to regulation of mines and development of minerals is thus guided by the 57 Act and the 60 rules. Whether reservation made by 62 and 1969 notification is any manner contrary to or inconsistent with 57 Act, in my view, not at all. Now, this was a case brought prior to 17A3 being. So the now approval is required of the central government. At that time, it was not. Whether the government of the erstwhile state of Bihar did not have the power to make reservation, which it did by 62 and 1969 notification, I think there was no lack of power in the state in making such reservation. I indicate the reasons therefore. Then they say at the bottom 133, no fundamental right nobody has, which we can leave. Then kindly see 134.
139, Mr. Dwivedi.
139.
Railway, first 6 lines.
I'm reading 139, Lord should just note 130.
Yes.
4 onwards.
Straight.
139 isn't.
The regulation of mines and development of minerals has been taken over and it's under its control by the central government to the extent it is manifested in the 1957 Act, which does not contemplate acquisition of mines and minerals. By the presence of keynote expression to the extent hereinafter provided in Section 2, the Union has assumed control to the extent specified in the provisions following Section 2. In my view, though the word regulation must in the context receive wide interpretation, but the extent of control as specified in 57 Act has to be construed strictly. The decisions of the court in Tulak and Bharat Coking Coal, Bajnath Kedia and few other decisions were this court held that with reference to declaration made by Parliament in Section 2 of the 57 Act and the provisions of that Act that the whole of the legislative field was covered were in the context of specific state legislations under consideration. In the context of subject state legislation, the whole legislative field was found to be occupied by the central law. The same is the position in Hingir Rampur, where whole of the legislative field relating to minerals was found to be covered by the declaration. In Section 2.
That's all, the first 5 lines was.
Yes. And they have dealt with all those. Ownership ki baat karte hain.
What else now, Mr. Yudi?
Also note para 141 where they have held that the state governments are the owner of the land and minerals.
That was by virtue of the Bihar Act, they said.
Yes. Justice Gokhale's judgment is concurring, who takes the same view. So therefore, one has to see in each case the state act. Your additional wala. 9B 9C तो हो गया. Mr. Singhvi's, in response to that, he referred to 5 cases, Odisha Cement and all those cases, to show that those cases took the view after India Cement, following India Cement, and they said that the power to tax on mineral rights would be located in entry 54 list 1 read with entry 97 list 1. Now, Lord, these are all cases where the Supreme Court was following the 7 judges' judgment, but they reveal that the court was struggling, as in quarry owners plot where I was arguing, here also, to locate where is the power flowing from. So in one case, they say that it emanates from 54 list 1, supported by entry 97. In other cases, no, not 97. It's only 54 list 1. None of them will not consider Sundara Ramayya, etc., because they were following India Cement, and it's a tax, and therefore, actually, there was no need to find out where it is located. But that was the position. But there is one grave danger, my lord, when written submissions, some paragraphs or some part of the paragraphs are quoted. There was a reference made to para 40 of synthetics and chemicals, which is now also under consideration in another bench. Now, para 40 is quoted, not synthetics and chemicals had nothing to do with mines and minerals. It was dealing with,
Denatured spirit.
the issue was whether the fee on industrial alcohol could be levied by the state of UP or not. So they refer to entry 52, an IRD Act, that is something similar to this MMRD Act, Industrial Development Regulation Act 1951. So having referred to that, they said that the field is occupied by those acts, right or wrong, your lordship will see in the other matter. But that was a case which had nothing to do with MMRD Act. And para 40 is 6 lines have been cited as if the court is holding that this entry 50 list is subsumed or can be, the power could be exercised under entry 54 list 1.
That's a little unfair because the next para says that it's not a mining case. But what is an interpret? Very next para says.
Let me point out your unfairness, please.
No, I'm pointing out my fairness.
Oh, I'll come later on. You can comment on me. I'm pointing out that my learned friend should have pointed out to your lordships that these 6 lines do not constitute the paragraph. They are not the finding of the court. They are submission of the council. And he has presented it by extracting 6 lines and telling your lordships that it is dealing with it. See para 40 minutes.
Page?
This is 1202, volume 5. This is unfairness. But I'm not attributing unfairness because I don't go engage in these things because it may be an error. And I'm not saying that the court was not cognizant. What I'm saying is that you know that this case does not relate to, and yet it is being relied upon for entry 50. So sometimes, my lord, in some other matters, some passing observations do come in. Please see para 40. It was submitted. The whole paragraph is about submission. My lords have got 1202.
Yes.
It was submitted in the statement on behalf of Union of India that the legislative competence of the state enactment in the various states will have to be determined by reference to the following entries in list 1 of 7 schedule, entries so-and-so in list 3. It was urged that there is dichotomy between 84 list 1 and 51 list 2, but this would not control the interpretation. There is no such dichotomy. It has also been stated on behalf of Union of India that while opium was in entry so-and-so, it means that Parliament will have power, but the power to levy excise duty on opium is given to the state. Similarly, medicinal and toilet preparations which contain alcohol and are fit for human consumption. The power of levy of excise is given. Entry 8 of list 2 similarly is not subject to, for the reason it was submitted. This is all submission of the union. And this, my learned friend cited is from the sentence, the power to levy taxes is to be read from so-and-so. And then the court again, so according to the Union of India, none of the entries is so-and-so. The whole paragraph is a submission. And my learned friend has cited it and is attributing unfairness to me. I am not attributing, but my learned friend should withdraw the words.
Just note my para 828. I don't want to engage in this. 828.
Naturally, you have to run away from that.
My submissions are there. Makes it very clear.
No, why should it have been included?
Because 828.
Surely you would have seen para 40 something a submission, not a finding.
Makes it clear why.
और कौन सा चीज 5 पिछला Last submission was of Mr. Khambata, the learned counsel, about implied limitation, drawing support from Justice Sikri's observation in Keshwanand Bharti. That is paragraph 11 of his submission.
Yes.
Well, the first aspect to be noted is that Justice Sikri's observation is in the context of searching for limitations on the amendatory power under Article 368 so as to prevent it from becoming absolute. But for this doctrine of basic structure, which was drawn partly from the fabric of the Constitution and partly from the word amend, as Justice Khanna interpreted it contextually. So this implied limitation theory is to curb absoluteness and draw a line beyond which the amendatory power could not go. But in the present case, it is sought to be utilized for the reverse purpose. That is, to expand the scope of limitation. So a limited power, a power which is a field which is already limited, it is sought to be expanded so as to make it so absolute that it destroys and takes away the field from the fold of the state and places it in the fold of the union. I have dealt with this in page para 16 of my submission, which is 1D. This is just a small note to cover the yesterday's submissions. So I have to the other submission was with regard to drawing 97 list 1 and article 248. I cannot do better than rely upon my Lord Justice Nagaratna's judgment. My Lord, your Lordships have dealt with article 248. State of Karnataka, your Lordships have said that you have to only see whether the particular field is enumerated somewhere or not. Article 248 uses the word enumerated and 97 uses the word mention. They are meaning the same thing. So we have just to see, once it is mentioned there, then there's no question of 97. No question of Article 248. The only thing is power will always remain with the state. Can only be limited. Whether you can go up to a complete limit, prohibiting or making it zero or not, it's up, as in Kesharam, I would submit, Lord, that your Lordships can leave it to the Parliament's good sense, Lord, to, in its wisdom and policies, to decide if ever they want to impose limitation 1. And limitation has to be qua each mineral for mineral development. So it can't be across the board. For example, even minor mineral you say is limited. So the Parliament, therefore, the government will have to, of the day which moves the bill, will have to apply its mind to which mineral should be allowed to be taxed, which should not be, in which case mineral right should be allowed to be taxed, where not, how much. But it can't be a broad brush. It has to be a rational and reasonable exercise. And 248 is completely out. In this submission, Lord, I have enclosed that judgment, US judgment. We don't need to go. Your Lordships have time again said US laws are different, Lord. But it was quite, the provisions were quite close, but yet different. I have demonstrated in paragraph 18, and I have annexed that judgment also, Your Lordships benefit, paragraph 18 of 1D.
Yes.
Particularly pages 145 to 147 are more relevant.
So is it time to thank you, Mr. Dwivedi, now?
I have closed.
Thank you so much, Mr.
I'm
Dwivedi.
grateful to Lord. I should thank you, Lordship, for giving me so much time
Thank you.
and
Thank you so much.
extending it beyond the lunch period. Lord. I'm extremely grateful.
Thank you.
I just want,
Yes, Sanskriti, Mr. Dwivedi, please sit by our side. So if there's something, you can always assist her.
Your Lordships, if your Lordships have my note, volume 1F.
What is your, thank you, Mr. Dwivedi. Thank you.
Your Lordships have briefly covered 4 points, Your Lordships.
Where is your note?
1F, 1F.
You don't have one. Shall I upload new one, Bita? One F.
This can be actually scanned and put up.
We've got it. We've got it here. Now it's scanned for us. Yes.
Click करेंगे तो scroll हो जाएगा.
Yeah. I know.
Yeah.
Yes.
Your Lordship, so the argument is, although Parliament does not have any power to tax minerals or mineral rights, but MMDR Act is exhaustive of all the fiscal exactions, and therefore state is denuded of its power. So, my lords, the expression used is colorless and neutral exactions. And my lords, there is nothing colorless about the exactions in our constitution, your lordships. They are structurally different, historically different, and a constitutional significance is attached to each of them, your lordships. So, your lordships, I will refer to para 2 of my written note. It is submitted that there is nothing colorless about fiscal exactions in our constitution. They are structurally distinct, historically and constitutionally distinct, meaning and significance have been attached to them and are never used interchangeably, my lords. Para 3, I can skip, your lordships, it is Jindal Steel. Tax is a compulsory exaction by the state in the capacity of a sovereign, your lordships. When it is imposing a tax, it is imposing a tax on its sovereign, as on its constituents. And when royalty is being levied, my lords, that is being levied in the capacity of the owner. So even the relationship in which the state is imposing a tax, that is different. That is sovereign taxing its constituents. Royalty owner imposing a consideration fee for parting with the mineral resources that it has. Sub-para of para 4, your lordships. The Constitution uses distinct expressions such as tax, duties, cesses, surcharge, fees, license fees, or fees for services rendered. Your lordship, this can be found in Article 1110, which deals with money bill. Distinct words, my lords. Then royalty is used in Schedule 6, para 9, my lords, of the Constitution. Fines, other pecuniary penalties, again used in Article 110. So how do we use it interchangeably, my lords? There is no concept of uniform fiscal exaction in our constitution, my lords. Each exaction or imposition are imposed under a distinct power, and they are distinct and not used interchangeably. Tax, duty, cess, and surcharge form one class of exactions, which is levied under Article 245, 246, read with the taxing entries. Fees is another class. Fees can either be regulatory or for services rendered, which is levied under 245, 246, read with general entries and entry 96 and 66. Now royalty in the field of minerals, license fees for the grant of spectrum, levy charged for parting with privilege in liquor trade is neither tax nor fees. It is the price charged as owner of these resources, and in the latter case, a price for parting with privilege. Constitutional bench in State of Punjab versus Devon's Modern Breweries has held that levy charged for parting with privilege is neither tax nor a fee, and it is simply a levy for the act of granting permission for exercise of power to part with privilege. It is neither tax nor fee and will not attract Article 301 and 304. Dead rent and surface rent are payable under MMDR Act to the state in the capacity of the owner and lessor of the land. When the lease is of a private land, the royalty, dead rent, and surface rent is payable to the private person. Here also payment is given to the private person in the capacity of owner and lessor. These levies are not mutually exclusive. State being the owner of the land can receive royalty for parting with the land with mineral rights and can also levy a tax on the same land in the capacity of the sovereign taxing its constituents. The power of state to impose tax on mineral rights under entry 50 is a power to impose tax. None of the statutory fiscal exactions mentioned in section 9, 9A, 9B and 9C are or can be in the nature of tax. Parliament has provided for payment of royalty, dead rent, surface rent, etc. under Article 245 to 46 read with entry 54, which is not a taxing field. To say that MMDR Act exhausts the field of fiscal exaction distorts the settled distinction between these impositions. Difference also arises on account of nature of relationship. When tax is being levied, the sovereign is taxing its constituents. Your Lordship, I can skip that. Para 8, it is neither tax nor akin to tax, nor can it substitute a tax. Your Lordship, then an argument was made regarding uniformity. Why is it so important that all the fiscal exactions are dealt with in MMDR Act? My Lords, all the subjects in list 1 are those subjects which were sought to be held to be having nationwide implications, and a uniformity was envisaged. But the fact that those subjects don't find mention in list 2 is that each state, Your Lordship, Justice Bhanupati in her judgment in general, my Lords, she has discussed the disparity in the state of development of the states all across. Each state has its own unique natural resources. The nature differs, the quality differs, the stage of development differs, the need differs. So to have a uniform fiscal policy for the entire country, my Lords, this is destructive of federalism, because the states should be in a position to devise their legislative mechanism to deal with their individual needs. So there can't be a straitjacket formula for list 2, my Lords. That was never the intention. Those subjects would not have been put in list 2, my Lords. Hazan Chandra's judgment, my Lords, 84, para 2 of this heading, my Lords. It says subjects regarding which uniformity was envisaged were put in list 1, and the other subjects, the state, and therefore, Your Lordship, an Article 14 argument can never be made by comparing one law of another state and of some other state. Para 4, like there cannot be any taxation by inference, similarly, there cannot be any limitation by inference on sovereign power of taxation. Firstly, limitations need to be expressed. Jindal has been covered, my Lords. And secondly, even the express limitations need to be construed strictly, my Lords. Constitutionally, taxation by inference is a paradox. Then, Your Lordship's fiscal federalism. The jurisprudence regarding federalism, which is the basic feature of the Constitution, is becoming more nuanced. And Your Lordships have borrowed these expressions from Your Lordship's judgment in Mohit Minerals. There is collaborative federalism, competitive federalism, and federalism involving contestation. The consultative and participative exercise of royalty fixation is an instance of collaborative federalism. The states designing their fiscal measures by giving incentives, tax holidays, exemptions, lower tax rates to attract investment or increase tax base is an instance of competitive federalism. The states contesting for their power conferred under the Constitution is the case of federalism in contestation. This aspect of federalism should not be seen as disruptive, but it is the bounden duty of the states to ensure that no limitations are imposed. Contestation deholds the Constitution in the interest of uniformity, national interest, Your Lordships. Article 249 deals with laws relating to national interest, my Lords. That deals with a situation where there may be a subject in the state list, but in the interest of national interest, there may be laws. So there's a procedure prescribed. The resolution has a fixed life of 6 months. So national interest, then you go to Article 249 if it is permissible. There are express provisions in the constitutions for situations requiring subordination of powers of the state in national interest, and the procedure is also described in Article 249. The states have plenary and exclusive powers over list 2 subjects, and that means they do not and should not have to knock on the doors of the center for imposing levies which they are exclusively empowered to charge. Knocking on the doors of the center for tax relating to list 2 subject is not collaborative federalism, but subversion of federalism. Therefore, fiscal federalism is the most basic and fundamental aspect of federalism. The existence of state depends on taxes, and they form the lifeline of the state, without which states are rendered nothing but paper tigers. Your Lordships, then the argument is limitation will include prohibition. And this is based on those judgments, Your Lordships.
Article 19.6 judgments.
Sorry, Your Lordship. 19.6 and those general provisions which say that regulation will include prohibition. Hindstone line of cases, my Lords. So if Your Lordships just turn to entry 50 first. This says taxes on mineral rights subject to any limitation imposed by Parliament by law relating to mineral development. My lords, my first submission is regulation word does not find presence here, my lords. The term is limitation. Regulation, your lordships, is found in entry 54. But here the power is given to the Parliament to impose limitation, not to regulate power of the state. You can regulate under entry 54. You can make laws for mining. You can prohibit mining of a certain mineral. You can prohibit mining of a certain, for a certain period, import. That you can do under 54. But here, word regulation is not there, limitation is there. So to import those cases which say regulation will include prohibition, that doesn't apply, your lordships. And your lordships, the term limitation is used in one another provision of Constitution, which is Article 134.
Is correct.
It's a very vital, yeah. Wait, just 1 second.
Regulation is of mining activity.
Your lordships, limitation is found in another provision, which is Article 134, which deals with appellate jurisdiction of this honorable court, your lordships. I'll just read it out. 134, sub-article 2. Parliament may by law confer on the Supreme Court and any further powers to entertain and hear appeals from any judgment, final order or sentence in a criminal proceeding of a high court in the territory of India, subject to such conditions and limitations as may be specified in such law. So, your lordships, when such restrictive words are being used in context of a court or of a co-equal organ, to say that limitation will include destruction.
Yeah.
So, under the regulatory power of 54, you can do whatever in the field of mining, my lords. But once you are imposing a limitation, you are not regulating the power of taxation here. You are imposing a limitation.
Yes.
So that is, and your lordships, Mr. Dwivedi has already cited cases on entry 57, my lords, but I just want to repeat, entry 50, if your lordship sees entry 57, list 2. This is one other entry, your lordships, where the taxing power of the state has been made subject to the parliamentary law. This is under 35 concurrent list.
And 35 refers to the principles for the formulation of rates.
Context of entry 57, your lordships have held that yes, they are allied subjects, but they are distinct. So in Assam judgment, your lordships, at page 53 of the main written submission 1A, your lordships, the issue was this: the Assam legislation had increased the rates of the taxes. So that was challenged being contrary to the parliamentary law. The Constitution bench holds that though the power are allied, one is power to tax, one is power to lay down the distinction, the principle for fixation of taxation. So yes, you can do it, but you can do it only under the general power. You can limit, you can also go to the extent of saying that 5% or maybe for next 5 years, you're not going to tax. But to say that under this limitation, you can regulate the power of state, my lords, that is an incorrect submission to, with great respect. My lords, I think I've covered.
Thank you, Sanskrit. Thank you.
Great.
Watching there.
One was supposed to respond. I think, we had we had said that only one rejoined, otherwise there'll be.
My lord, in the beginning, my lord, we took less than time. What was your lordship allotted to us? My lordship allotted 2.5 days. We concluded before 2 days, my lord. My lord, both of us, my lord, will conclude within the time which is remaining. We are in rejoinder.
All right. All right, just 2 or 3 minutes. Yes.
Very good. My lord, the entire debate is list 2. Now, Lordship may kindly note that list 2 has entries from 1 to 66. In effect, there are 7 entries have been deleted. There are 59 entries in list 2. Out of which 36 entries are without any restrictions.
Just 1 second.
Yes, Lord.
So now out of 66,
out of 59 entries today in list 2, I put that in my volume 1C, my lord, page 52 onwards. Out of 59 entries in list 2 today.
How many were deleted out of 66? 7 were deleted.
7 have been omitted, my lord. Yes. By different amendments, including 101st Amendment. 36 entries are without limitations whatsoever. Or restrictions, I will not use the word limitation, restrictions whatsoever. And (23) entries have limitations of different degree.
Or you would say restrictions of various.
Restrictions of different degree, which I have put in my written note in the chronological order from category 1 to category 10 in page 52 and 53 of volume 1C. Lots.
Where is it? Your written note is volume 1C page?
Page 52 and 53. If your lordship only see one entry, my lord, I have put in chronological order.
Yes.
Lordship may only see one entry, 37 of list 2. And my lord, 50 of list 2. Wide range of difference, my lord. For example, 37, my lord, I have quoted them subsequently in 58, 59 onwards. I have summarized them at 52. If your lordship see page entry 37, my lord, which I have extracted at page 59 of volume 1C, elections to the legislature of the state subject to the provisions of any law made by the parliament. It's very broad, my lord. Now, lordship may contrast it with entry 50 of list 2. The argument of the other side is, my lord, once there is a provision of law made by the parliament, entire entry is eclipsed or gone. My lord, these are of different degree. The limitation itself has a limitation. And those degrees, my lord, I have put it in page 52, paragraph 2.
Where have you put it, Mr. Ansari?
Yes, in the descending order, I have put it, my lord. Lordship has asked, my lord, what are the limitations, my lord, which I have tried to illustrate, my lord, in paragraph 4, page 53. I'm sorry.
52. Okay.
My lord, sir.
Subject to expect.
Yes, page 52, my lord, the Chief Justice has got it, my lord.
Yes.
Because first category is subject to any law made by the parliament, is widest enough, my lord. Second category is accept, that is in entry 3 and 65. Third category is not specified, subject to or other than. Then, my lord, not including, other than, to the extent, subject to 1 and 3, then subject to 1, then subject to 3, and thereafter comes, my lord, subject to the limitation imposed by the parliament. The argument is, my lord, this is the widest enough, which is, my lord, in fact, this is the least restrictions, my lord, which the parliament has thought it to impose, my lord, or the constitution sought to prescribe, my lord. Secondly, my lord, lordship have been asking, my lord, what are the limitations which I have tried to give by way of illustrations, my lord, in page 54, A, B, C, and D. Paragraph 4, my lord. It can be, my lord, extent or quantity of mineral that can be extracted, that is by way of regulation. You can, you can also say on what basis the valuation should be done for the purpose of taxation. It can be price fixed by the Indian Bureau of Mines. It can be pithead price. It can be sale price. It can be tax at the point of extraction of mineral at the dispatch of mineral. It can be a ceiling, my lord, repeatedly asking 500%, there is, my lord, we are not saying that Parliament cannot do it, limitation. Parliament can say, all right, it cannot be more than so-and-so percent of so-and-so. So it can put a ceiling. The period of exemption of a particular period or a particular area or a particular mineral, these are the limitations, my lord, and not the complete abridgment, my lord. Para 5 and 6, my lord, my learned friend Mr. Dwivedi has taken to your lordship, my lord. Now, my lord, para 7 is important. If your lordship kindly come to page 55. Now, my lord, entry 54 before 6th amendment was taxes on sale or purchase of goods other than newspapers. It stops there, my lord. This subject to 1992 has come under the 6th amendment. And before that, my lord, the 6th amendment, there was no power of the Parliament to tax on sale or purchase of goods. It was introduced only by the 6th amendment and my lord, it was only controlled by Article 286, which I have extracted at page 56, my lord, footnote. There were limitations on the power of the state by virtue of Article 286, which were very specific and precise, that where you cannot tax outside, you cannot tax import, you cannot tax in the course of interstate trade or commerce, you cannot tax goods declared to be essential for the life of the community, which were subsequently made, my lord, of special importance. Article 286, as, my lord, adopted, provided in clause 3 of Article 286, saying that if Parliament cannot be, my lord, no law for the purpose of imposition of tax declared by the Parliament to be essential for the life of the community, which were subsequently made special important, that is, they declared goods under the CST Act. So, my lord, these are the limitations, my lord, and not a power of enabling as we have put it in the beginning, my lord. This is limitation power and not an enabling power. And finally, my lord, Form K has been read to your lordship as it is a statute levying tax. If your lordship see Rule 31, which prescribes Form K, it says as nearly as in Form K or in a form as near thereto as circumstances of each case may require. So that is where the contract is, my lord. If your lordship kindly see Rule 31, my lord, which is in volume Volume 4, page 1644.
You have quoted it at page.
I have quoted it, my lord.
57, page 57.
Yes, my lord. Page 57, I have quoted it. Rule 13, my lord, Form K is my lord, it's a modal form. And it can be varied as per the statute itself. And it says in Form K or in a form, my lord, if it's a taxing, my lord, it cannot be left to the parties to bargain it. So that is where it has been left to the discretion of the parties, to what extent they can modify. And that has been read to lordship, my lord, as if it's a taxing power by the central. And finally, my lord, what is, yes, and the judgment, my lord, the Chief Justice said, my lord, I have given in para 13, that the form cannot control Justice Chinnappa Reddy's judgment. That is, my lord, 1986, 1 SCC 264 at 319 para 69, which says surely form cannot control act, rules, or the direction. It can definitely not control, my lord, a constitutional entry, a sovereign power to tax by the state, my lord. And this, and finally, my lord, both the mineral companies and, my lord, even the Union of India has relied upon the House of Commons, my lord, debate to interpret a constitutional entry of 13th May 1935. What they were debating, my lord, was, one of the issues was whether Indian subject of His Majesty should be there or British subject domicile in India is there. So those debates cannot be relied upon. I'm so sorry. If your lordship kindly see that debate, just note the page where it is. One more objection, final, my lord. The affidavit of the Union of India, if your lordship see para 12, I have quoted it, page 57. They say, my lord, entries in the Union of India affidavit, I am quoting, my lord, of 26 February 2024, entry of list 2, list 9 cannot be absurdly wide reading, and that the provisions of MMDR Act must be given wide and liberal construction. Lord, this cannot be the stand of the Union of India, my lord.
Yes.
On affidavit before your lordship's court, my lord.
Thank
I'm
you, Mr.
extremely
Ansari.
grateful, my lord. We are extremely grateful.
Thank you, Mr. Ansari. Mr. Reddy?
I just want to give
Mr.
a
Reddy, yes, sir.
reference.
Let Mr. Reddy conclude.
My lord, before
Reddy.
Mr. Reddy begins, I just want to renew my request. My lord, I see it's only for 12 minutes to go. My lord, there are some new points which have been made because actually we opened the case and Mr. Dwivedi has.
No new point made. There was no new point made.
My lord,
It's an explanation.
if I had time, I would have, my lord, told your lordship what is the new point.
The decoupling was a phrase you used, so that he's.
No, but my lord, I'm sorry. I did not have. If my learned friend had opened, I would have replied. I opened with decoupling. He has given an answer to which I have not had a point to say where he is wrong. So, my lord, that's what I meant.
Mr.
If your
Sarve,
lordship
now,
permits a
but
note.
if we permit you, there'll be another round. Sorry, joined by there.
No, just a note. My lord, please allow us to deal with what he has said. I will not go back to my original. That your lordship has already. The two points which he made today, entry 49, entry 50, and land, and he made some submissions on when the land is decoupled. Just a
What
4-page
we'll do
note.
is, Mr. Sarve, you can file a note not exceeding 3 pages. Just
Yes, my lord, done. Yes, absolutely. And not necessarily 3 pages. My lord. I agree.
Lord, sir, can I also file a note only 2 to 3 pages, my lord? On new points.
All right.
Especially entry 49, my lord. That's what our
All right. Certainly, Mr.
And my lord, we'll file it by end of Friday.
So one second.
Should we be limiting the,
I think what
the
we-
size of the note, or should we be regulating the size of the note?
My lord, as long as you lordship allow us to develop it.
What I suggest is that Mr. Solicitor, Mr. Salve, Mr. Bagaria, give us one note of not more than 3 pages. Please put your heads down together and give us one note. I think that will be better.
Try and do that.
Conceptually better.
Please, my lord. We shall do that. We will do that.
Yes.
I just wanted to give a reference to the notifications where the royalty was revised, excluding the state of West Bengal. Just that note the period.
Put it in the note. Put it in the note now. We have pulled out the pen drive now.
You can go in the transcript.
Like
I just need the page
pulled out
number.
his hearing aid.
No, I just
Deeply
need
obliged.
2 pages references only. I just
That volume.
The reference of 2 pages. 2004 revision, Miller. Is that page 2170, volume 4. 2007 notification is at volume 4, page 2170. And 2004 notification.
We are less than 2 days, Lord.
Yeah, this was the transcript, Miller.
There is a prohibition.
2004 notification is at page 15312, volume 3.
May please your lordships. My lord, volume, my lord, I'm grateful, my lord. Volume 1 is my submission. I don't propose to read it because I have very little time. I'll just state, my lord, 3 or 4 points that I have touched upon in my note. Lordships may kindly have volume 1 for your lordships reading
the
later.
points,
Yes, the point is, first point, my lord, I touched upon in my submissions is that minerals do not automatically vest in the state. My lord, that's a wrong concept. My lord, the judgment of this honorable court, my lord, in Tresiamma Jacob, my lord, specifically refers to different lands having different characters. My lord, it notes, my lord, that in different states, my lord, there are different tenure rights. My lord, for instance, my lord, when surplus lands reverted to the state, states then grant, my lord, what are called as tenure rights. Raitwari pattas, my lord, in the south of India, and some other terminology used in rest of the country. When Raitwari pattas are granted in respect of lands that revert to the state, their state only grants cultivation rights. So subsoil rights remain with the state, surface rights remain with, my lord, the cultivators. This is one category of land. Rule 72 in the morning, my lord, my learned friend Mr. Ganguly showed your lordships. The statute was cognizant that there could be one category of lands like this. The statute was equally cognizant there could be private lands where the subsoil rights, my lord, vest in the persons who own the land. Like in Tresiamma Jacob's case, my lord, there was one category of landowners who were found to have subsoil rights. But in the House of Commons debate that is placed for your lordships, it notes the position, my lord, at the time Government of India Act was being made, that in Bengal, state of Bengal, my lord, while it was believed that under the British rule, my lord, only the surface rights were granted, for over 100 years, each of the landowners were exercising subsoil rights without any complaint from the Crown. So therefore, those rights in that sense remain ceded. So my lord, that this concept that of all minerals vest in the state, therefore the royalty exclusively goes to the state, my lord, in my respectful submission is a wrong argument. So my lord, that's one point I've touched upon, giving some details. But I also said that from 1901, my lord, the Mines Act, followed by the successor 1923 Act, 1948 Act, the rules, 1957 Act, consistently throughout recognize this position that minerals do not automatically vest in the state. But this is very important, because if minerals do not automatically vest in the state, and if the royalty and dead rent becomes payable to the mineral owners, it is, my lord, actually a consideration for one-time finite resource. My lord, royalty, the expression, I have touched upon it in my submission. It has been explained, my lord, to say that unlike land, my lord, where cultivation can go on a recurring basis, my lord, in respect of mineral, it is a one-time finite source. So an owner of a land who has the subsoil rights, it could be the government, it could be, my lord, a private person, it could be a limited right of a private person or the government having subsoil rights. When they give out, my lord, this mining lease, my lord, the lessee extracts the mineral out. So there is a one-time, my lord, complete exhaustion of a finite mineral resource. Therefore, there's a compensation that has to be paid to the landowner, who loses that mineral forever because it is a finite source. So royalty is therefore not an exaction levied by law. It is not a tax. My lord, royalty is a consideration for the grant of right. What 9 does in the regulatory sphere, and it is permissible, is it caps the consideration that can be levied, my lord, by a person who owns the mineral. But for 9, every person can quote his own right, my lord, as to what he would ask for the purpose of, my lord, giving a land on mining lease. This may come in the way of, my lord, the country's development. So regulation steps in, section 9 comes in, royalty is fixed, dead rent is fixed. My lord, my learned friend Mr. Dwivedi showed to your lordship, there is a little leeway in respect of private landowners. Dead rent is fixed as per Schedule 3. Royalty, my lord, may not be fixed in respect of private landowners, because that rule, my lord, 45 does not take into account that royalty fixation in interstate to private owners. So, my lord, if royalty is therefore, my lord, in my respectful submission, not an exaction, it is actually a regulatory limitation of consideration that can be taken under a contract for granting mineral rights. So if it is limiting the consideration, a contractual consideration, it can never have the sovereign character of tax. And if it has, if it were to be contended, and it was, and I'm therefore meeting that submission, that it has every trapping of tax, but it can never go to a private person. If it is going to a private person, and it is not going to the state, state gets nothing in those categories of lands and in those states where subsoil rights may vest exclusively with private people also. So, my lord, there is absolutely no element of tax. My lord, this is one point I touched upon. My lord, only one other point. My lord, with regard to tax on land, my lord, please see the situation when they say that 550 completely eclipses 49. My lord, eclipses, I'm using the word literally, my lord, not in the legal sense which Dwivedi was pains to point out. It cannot be, because land is, my lord, a continuing, my lord, it has a continuing existence. Land has been in existence throughout. 50 comes in only and only when a mining lease is executed. If there is no mining lease executed, I may have mineral in my soil, but I am carrying on cultivation. But I do not come under 50. State cannot tax me, because it is land and I am cultivating the land. I am subject to 49. 50 comes in respect of one aspect of mineral rights. But please see the situation after the mining is complete. But mining cannot be forever. It can go on for 30 years, 50 years, depending on the mineral richness of the soil. After 50 years, land reverts to being land again. It can be taxed again under entry 49. So pre-mineral lease 49, post exhaustion of mineral or determination of lease 49 applies. So 49 cannot go into this hiatus for the limited period a mining lease operates. So mining lease deals with a different aspect of mineral rights. land remains land. It's a permanent feature. It continues to be land even when it is being mined. It does not take it outside the taxation fold. But if a government in a given case, they have to abuse 49 power to surreptitiously, my lord, override any limitations that the parliament by law may impose, my lord, then the court would strike it down for being a colorable piece of legislation. So, my lord, therefore, my lord, I touched upon this aspect that land and 49 is something that cannot be made subject to 50, which is purely temporal and on a completely different aspect. My lord, the last aspect, my lord, that I touched upon, my lord, that House of Commons debate that has been placed by lordships, my lord, that's a very interesting thing. The Joint Parliamentary Committee, when it made recommendations on Government of India Act, the recommendation it made, my lord, to the federal government. That went before, my lord, the House of Commons when they debated Government of India Act. Post-debate, post Mr. Percy's concern, Lord Percy's concerns that were expressed, my lord, the British Parliament, my lord, made the Government of India Act, which actually moved it. It is an improvement on the Constituent Assembly debates. It was not originally, my lord, in the provincial list. Notwithstanding these concerns, my lord, they wanted to give this power to the provinces because provinces must realize some revenue. So contrary to the Joint Parliamentary Committee recommendation, my note, my lord, gives us entries list. It was moved to the provincial list. So Percy's contentions. But very importantly, my lord, the last of the submissions, my lord, I put it in my note. My lord, a case arose, my lord, from Canadian, from the country of Canada, my lord, on British North American Act. My lord, there were two entries. My lord, the federal list had an entry saying that it would deal with incorporation of banks, trade and commerce. Provincial list said that provinces can levy tax on entities for augmenting its resources. But a matter went up before the Privy Council. Contention was if provinces were to act excessively and collect heavy taxes, it would come in the way of regulation of trade and commerce by the federal government. Such power must not therefore be ceded to the provinces. My lord, I have placed that judgment. That judgment, my lord, which is not on identically worded terms, but on similar arguments that have been advanced, were rejected by the Privy Council stating that when this act vested this authority with the provinces and their governments, it did not suppose that these provisions will be used injuriously, excessively or arbitrarily. It reposed faith in these provinces, my lord, to exercise that power judiciously, I'm sorry, my lord. So therefore, my lord, that judgment may have some guiding factor for your lordships. I've placed it also as a part of my judgment. But I'm deeply grateful, my lord, your lordships have granted.
Arguments concluded, judgment is served.
Thank you. Thank you, everyone. Thank you.
Yes.